with no recommendation by Commissioner Schoonmaker, and the second is by Commissioner Bustler. All in favor, please say aye.
Aye.
Any opposed? That resolution moves to next week's non-consent agenda. Madam Clerk, next item, please.
The next item is item number 51, ordinance O-21-11-101. It's amending Knox County Code, Chapter 42, by repealing sections 42-51 through 42-66, and by adding a new section 42-51 to adopt the provisions of Tennessee Code annotated subsection 8-8-401, ex-sec, known as the County Sheriff's Civil Service Law of 1974, in order to bring Knox County into compliance with state law. This amends ordinance O-90-9-111, adopted September 10, 1990. Ordinance O-91-8-114, adopted November 25, 1991. Ordinance O-94-10-101, adopted December 1, 1994. Ordinance O-95-4-101, adopted April 24, 1995. Ordinance number O-19-1-101, adopted February 25, 2019. Ordinance O-20-7-102, adopted September 28, 2020. Ordinance number O-21-7-105, adopted August 23, 2021. And ordinance O-21-7-106, adopted August 23, 21. This is on first reading.
Is there a motion? I'll remind commissioners, this is an ordinance, so we'll have to move to, right. We'll have to move forward with no recommendation. Is there a second? Second. Second is by Commissioner Jay. We have a motion by Commissioner Bustler to move forward with no recommendation, and a second by Commissioner Jay. This is an ordinance. It does not require a two-thirds vote to move forward to the meeting, I would not think, but it would require a two-thirds vote in order to pass on first reading next week. Commissioner Daly, you have the floor.
Yeah, can we get an explanation from the law department? And I see the merit council here. What's going on?
You want the long or the short? Because it's complicated law like the Jordan case back 15 years ago. I'll try to make it short.
Yes, yes, ma'am.
This, like the Jordan case that many of you may remember from 15 years ago, is kind of the law of unintended consequences. Back then, if you recall, when we put in the term limits, some of the constitutional officers filed a suit up in Chancery Court saying, did it apply to them as constitutional officers? And that was the sole question before the court. Well, the chancellor, being the chancellor, goes back and starts from day one on the charter and says, oh, by the way, you don't even have a charter. You do not have a legal government because you didn't follow the terms of what the charter statute said you had to do. That went up to the Tennessee Supreme Court, and the Tennessee Supreme Court agreed with the chancellor and said, you're right, you do not have a legal government or a legal charter because you did not follow the law. That was an unintended consequence of the lawsuit that was brought simply to ask whether or not term limits applied to constitutional officers. This is the same type of thing. What's happened here is in the Merit Council, there was an issue brought up in front of the three-member Merit Council about whether or not the sheriff could be ordered by the Merit Council, and that the Merit Council had authority to tell the sheriff and the taxpayers that they had to supply a non-uniformed administrative person a late model Chevy Impala car, and a gas credit card for her own personal use. The opinion of the law department at that time and of the sheriff's outside counsel, I didn't represent the sheriff in that one, was, no, you can't do that. You have no authority to tell the taxpayers that they've got to supply a personal use card, gas credit card. The result of that was, as outside counsel was, the sheriff's counsel was representing the sheriff, which the sheriff is entitled to representation, filed a lawsuit in Chancery Court contesting that issue. And amongst one of the issues in there was talked about the state law which was passed in 1974, which was 4 years after the original private act setting a merit council here, and referred to that. And I thought when I read that, although I'm not involved in that, I said, that just doesn't sound right because we don't operate under state law. Well, so here's the unintended consequence. Went back to see whether there was a problem there, and indeed there was. And that's set out pretty much as best I could do in the whereas clauses. Right now, if it went in front of the chancellor and the chancellor ruled the same way he did in the Jordan case, we're going to have a chancellor that says, you hadn't got a merit system. You don't have one because you didn't follow the law. Now, what's the consequence of that? What the Supreme Court said in the Jordan case was, I realize you've been operating under this for 15 years, so I want to declare that you had a de facto government. So what you did in passing those resolutions and ordinances would be valid, but by golly, you better get it done right going forward. So that's the situation that this is in right now. This lawsuit tries to stove that up so that if the lawyer representing the sheriff pushes that issue in front of a chancellor, we won't wind up with the chancellor saying you don't have one. Now, what's the difference? Virtually no difference. The protections for the uniformed officers and, in fact, all employees under the state statute is the same as it is now. And the Merit Council, as it is now, has virtually the same power, not virtually, it does have the same powers under the state law that it has under this ordinance that they have modified from year to year, which is a different story, and that's the long story. So what we're trying to do with this, or what I'm trying to do, is get this done where that's not an issue anymore, and that we have a merit system protecting all of the uniformed officers on the same standards that we have right now. And the rules, the other part of it is that the Merit Council can adopt rules. Most of what the Merit Council has now are the rules that they have previously adopted. If you adopt this motion and establish the Merit Council under this, all the Merit Council's got to do is say, we adopt our rules that we've been operating on. And so there's no change whatsoever. So that's the short story.
Thank you, Mr. Buuck. Any further questions or discussion? Commissioner Ward.
I've got, I'm thinking of this from a business perspective, so kind of stay with me on this. The law director is my personal counsel as a commissioner. That's his job, to counsel me. And he's bringing forth legislation for me to pass. So who do I turn to now to counsel me on this legislation? Because for me to do my research from this week to next week, we have to vote on this, I would typically go to the law director and say, hey, what is your professional opinion on this? Who do I now go to for a professional opinion on this piece of legislation? Because I can't go to him because he's, at this point, a bias factor, because I'm voting on his legislation. It's not any of our legislation.
Thank you, Commissioner Ward. I did have a question, and this is not an adversarial question, Mr. Law Director. I was asked this by someone else. Can the law director initiate an ordinance without a commissioner as a sponsor?
Sure, the law directors initiated a lot of ordinances, and that's been done in the past. In fact, my recollection is back in 1990 when they did all this charter thing, that there were some ordinances that were requested by the law director.
Thank you, sir. Any further questions? Mr. Smith.
Thank you, Mr. Chair. I want to ask the first question is, do we have a charter? Do we have a valid charter?
We have a valid charter. The way that charter amendment talked, not the amendment, but the way the charter talked about was that when you enacted a charter, you could enact all and incorporate all private acts, okay? So, but And that would keep the private act in place. Well, two things happened. Number one, they didn't do that. They
It
went
was an opt-in, not opt-out.
do what?
It was an opt-in to private acts, not opt-out of the private
It was
act.
in automatically. You didn't have to take any action, but the action taken at that time was to rescind all private acts. There's a list of what they rescinded as private acts. Then they went, so when that was done, there was no merit system. It was done. So then the only way they could get a merit system was to take over the state statute of 1974, which read virtually the same as the private act that we had, that the legislature had given us in 1970. So when they did that, they didn't follow this Chapter 74, or the Merit System Council Act of 1974. Bottom line is this: that's going to get litigated. It's going to be expensive. Chancellor might rule the same way he did in Jordan, and he might not. I don't know. But there's one way to prevent it.
Were there any other private acts that were excluded?
Yes. They rescinded, if you look in the front of the Black Book, there's a rescission of, I don't know, there's 20 some odd private acts that were rescinded.
Did the county commission at that time take up action to reinstate all the policies and ordinances in place?
No, they did not. They picked and chose what they wanted to redo, and then they redid their own version of it. They didn't just come in and say, we're going to take the Private Act of 1970. They created their own new ordinance.
Okay, are there any other areas in which we need to address this because of these actions?
That I don't know. The only reason I know this one is because it's in litigation. It's going to be litigated.
How did it take this long since 1990 for anyone to discover this?
Well, I don't know. It took 16 years for them to discover in the Jordan case that they didn't have a charter. So I don't know why on this one. That's what I say. It's the law of unintended consequences. It never would have happened if the Merit Council hadn't said that the sheriff and the taxpayers, that the Merit Council would tell the sheriff and the taxpayers they got to provide a private vehicle and a credit card to an employee.
Thank you, Commissioner Smith. Any further discussion? The motion is to move this forward to next week with no recommendation. Do we need to do a roll call vote to do that? Because it's an ordinance. Okay. Commissioner Biggs?
Thank you, Chairman Beeler. I was hoping, earlier I asked for Chief Rubble to be here from the Knox County Sheriff's Office. He was actually in the Law Director's office back in 1990 whenever this was originally drafted. He could probably have a better grasp on some of the things, and hopefully some representation would have been here. I see Merit Council's here. I have a plethora of questions as well. But what Commissioner Ward was talking about, I believe in that as well. And we keep going back to the same old, I feel like we're, talking about a specific case who the sheriff's office has their outside legal counsel and he's here, and everybody has their own outside legal counsel. So I'm under the impression that we're probably getting pretty close to needing that as well. And I don't care to make a substitute motion for that, but I think that might take a little bit longer than next Monday before we can get our own outside counsel. So, how would that motion look, Chairman?
I don't know that motion would apply to this particular ordinance. If you're looking to seek outside counsel for the commission, I suppose you'd have to make a separate motion.
And it wouldn't affect this ordinance at all?
I don't know that it would pertain to this ordinance.
You could postpone the ordinance until you get legal counsel.
You could postpone the ordinance. I would think we'd want to do that at the voting meeting, though, wouldn't we?
Okay, that's fine. I'll wait till next week.
Okay.
I do want to point out that this lawsuit is ongoing up there, and we could get a decision adverse to that and it well could be that the chancellor says, hey, you ain't got a merit system. I'm just saying this is a very easy, slam dunk, easy way to cure the problem.
I'm sure commissioners will have further questions next week at the voting meeting. Commissioner Ward, you have the floor.
I just want to clarify, you and I have a very good relationship, and I always go to you for this kind of stuff. for me, in my business life and in my commission life, I always have a lawyer that I go to check myself. That's what you're there for. You're my guide. And in this circumstance, I can't go to you. I want to make sure you understand it's not like a personal thing. It's just.
I'm just telling you,
business
here's
person.
what I'm telling you. There's
Yeah.
a lawsuit going. It's going to be decided by a chancellor,
Yeah.
one way or the other. I'm just telling you that that's what's going on. That's a fact. And I'm giving you a way out of it. I'm not saying it's right, wrong, or indifferent. I'm just saying you got a lawsuit going, and it's going to be answered by the chancellor.
Sure. I also have an obligation to the 50,000 people that elected me to make sure I make the right decision. So me seeking legal counsel, in my opinion, is the best way to find out what the right decision is. Not saying that you're wrong. You're probably right, but I can't.
Wouldn't have said it if it wasn't right.
I know that. Like I said, you and I have a good relationship, but I need to make sure that I do my due diligence. So if there's an option that we use legal counsel from another department even, I'm open to that.
I'm like the chairman. If you have the authority under the charter to hire counsel, the commission does, and hire counsel and pay him, it's just, that's your choice, and if that's what you want to do, but it's not going to change what happens up in the Chancery Court.
Understood.
Commissioner Smith.
Thank you, Mr. Chair. Mr. Law Director, I have a couple more questions. I'm trying to get clarity of this. I just got this Thursday, and I do have questions. I don't want to wait until next week to ask them all because I want to try to figure out between now and then where I stand. You say this is because of an ongoing current lawsuit, and I guess your speculation is that if the Chancery decides, he can say that we don't have a legitimate merit counsel. But at the same time, didn't the Chancellor once look at our charter and we didn't have a legitimate charter, but we've been operating as such, and they let that stand? Could that not be the same circumstance with the merit counsel?
I referenced that earlier when I said that the Supreme Court said that, for those prior 16 years, you had a de facto government, so the ordinances and resolutions you passed are valid. So that's what the Supreme Court said, and I said the same thing here. What they've done in the past would be a de facto merit counsel.
Okay, and you think that would have bearing on how the Chancellor would rule?
I believe the Chancellor, if he looks at the facts, the Chancellor for certain is going to look at the Jordan case. No question. No Chancellor would not look at the Jordan versus Knox County case. How he determines or interprets it and the facts, I don't know. I'm not passing judgment on that, and I'm not involved in that.
Thank you, sir.
Thank you, Commissioner Smith. Commissioner Daly.
Thank you, Mr. Chair. This will be on a first reading. We've got 2 readings. I would suggest that if Commissioner Ward get a hold of the Comptroller's office, send that resolution, and you get an answer out of the Comptroller's office. I think that would be the first step before we even talk about hiring a lawyer. Is get an opinion from the Comptroller's office.
Thank you, Commissioner Daly. Commissioner Jay.
Thank you, Mr. Chairman. I would also just encourage everybody to maybe start a thread on our commission forum with any pertinent questions. I'm sure we all might have similar questions or might want to learn about them, and that's a good way for us to all communicate.
Thank you, Commissioner Jay. Any further questions from commissioners? The motion before us is to move this ordinance forward with no recommendation for a first reading at next week's commission meeting. That motion was by Commissioner Bustler, second by Commissioner Daly. All those in favor, please say aye. Aye. Any opposed? That moves forward to next week's meeting.